Hey guys, welcome back to another new videos and LawGuru welcomes you. So today in this video we will be discussing the topic that is, can anyone marry again during the lifetime of husband or wife? So here in this case we will discuss, can anyone marry, first case or instance. Secondly, if that person marries again during the lifetime or of husband or wife, then what will be his punishment, his or her punishment. Okay, so let's start this video. If you have not subscribed my channel, please go subscribe so that you all can get law related videos regularly. So let's start this video. So this topic is provided in section 494 of the Indian Penal Code. As per section 494 of the Indian Penal Code, if a person who is already married gets married again or marries again with another girl or another person while their spouse is still alive, this second marriage is considered illegal. If that person has committed the offense under section 494 of the Indian Penal Code, then that person can be punished with imprisonment for up to 7 years, and that person shall also be liable to pay a fine. Okay, now there are two exceptions that are provided in this section. First exception is that if the court has already declared a person's first marriage invalid or void, then they can remarry without any legal consequences. Secondly, if a person's spouse has been missing and unheard for at least 7 years, they can remarry without facing punishment. However, before remarrying, the person must inform their new spouse about the missing status of their former spouse and what they know about the situation. Okay, now we will discuss the essential elements or requirements to constitute the offense of bigamy. This offense is also known as bigamy. First point is the existence of a prior lawful marriage. In the offense of bigamy, one of the essential elements is that of the existence of a prior lawful marriage. The mere subsistence of a prior lawful marriage itself declares the subsequent marriage void or invalid or illegal, because it confirms the existence of a living wife or husband of such individual. In case the prior marriage is not valid in the eyes of the law, then marrying again will not be labeled as bigamy. Okay. Second point, that is validity of subsequent marriage. The second essential element to constitute bigamy as per section 494 is that the subsequent marriage in question must also be a lawfully valid one. The couple willing to marry must take part in all the mandatory rituals and ceremonies as is required in the personal laws that governs their marriage. Okay, and lastly, that is existence of the partner from prior lawful marriage. The sole basis of the second marriage being void or invalid shall be due to the existence of the partner from the first marriage or a prior lawful marriage. This means that the wife or husband of such individual from the first marriage must be alive during the time of the subsequent marriage to declare it void and establish the case of bigamy. Okay, now all the essential elements I have discussed. Then I am moving towards the nature of the offense under section 494 of the Indian Penal Code. So what's the nature of the offense under section 494? Firstly, this offense is a non-cognizable offense in which the police cannot arrest the accused person without the permission granted from the court. Okay, that I have discussed, or I have made a video on cognizable and non-cognizable offenses already. Please go watch that video for better understanding in this case. Okay, now secondly, it is a bailable offense, as almost all the non-cognizable offenses are bailable, just like in the case of section 494 of the Indian Penal Code. Hence, the accused of the bigamy can receive bail from a court as a matter of right. Okay. Thirdly, it is a compoundable case. The offense under section 494 of the IPC is compoundable. As per section 320 of the Criminal Procedure Code, the accused and his or her spouse can compound and settle the disputed matter. Okay, and lastly, this case or this offense is triable by the magistrate of first class only. The first schedule of the Criminal Procedure Code provides that the offense under section 494 of the Indian Penal Code shall be triable by the magistrate of first class, who is eligible to pass a decree that punishes the convict for up to 3 years. Okay, now I am moving to two case laws. The first case law is the Sarla Mudgal versus Union of India and others, 1995. Here, in this case, there was a question of whether a Hindu married man can solemnize a second marriage during the existence of his first marriage after converting to the Muslim religion, which allows bigamous marriage. So the question in this case is this. So the Supreme Court held that the second marriage is void and convicted the accused person under section 494 of the IPC due to the presence of all the essential elements to constitute the case of bigamy. Okay, now the second case, that is Lily Thomas versus Union of India and others, 2000. In this case, the Hindu married man had converted to the Muslim religion only for the purpose of marrying for the second time, not because he had any genuine faith in that religion. This was established by providing evidence that the accused person did not perform any Muslim religious ceremonies or change his name. The court here decided upon the merits of the case that the accused is guilty of the offense of bigamy, although he converted to Islam religion under section 17 of the Hindu Marriage Act 1955, read with section 494 of the Indian Penal Code. Here the Supreme Court finally quoted that freedom of religion is the core of our culture. Even the slightest deviation shakes the social fiber. Okay, now I will discuss, or I will tell the punishment that I've already discussed earlier. The person who commits the offense provided under section 494 of the Indian Penal Code by marrying again during the lifetime of husband or wife shall be punished with imprisonment for a period which may extend to 7 years, and that the particular person shall also be liable for fine. The amount of fine shall be decided by the appropriate court after examining the facts and circumstances of the case. The Indian Penal Code also does not provide for a minimum punishment for this case. Okay, I hope this video is clear to you. If you have any doubt, please do comment, and if you like this video, please press the like button, share it, subscribe for more such videos. For then, stay safe. Thank you.